Hello, everyone. Welcome, and thank you for joining us today on Level Up Law, where at South Carolina Legal Services, we're leveling up your legal knowledge on the different areas of law we practice in. I'm Susan Engel, Senior Staff Attorney with South Carolina Legal Services, and I'll be the moderator of the webinar today. And we are joined, as you can see on screen, by our attorneys Jennifer Rainville and Taylor Ott. Taylor is the head of our elder law unit, and Jennifer heads up our probate and heirs property unit. They'll be talking today about probate and heirs property and the things you need to know to be prepared. As always, we want you to just note that this is being recorded, and those slides and recording will be posted on our YouTube channel later this week. Do keep in mind that we're providing general information for the public and not legal advice. So always consult an attorney for any specific legal issues that you might have. And also at the conclusion of this presentation, we will provide information on how you can apply for free legal assistance at South Carolina Legal Services, or if you're an organization that serves the public, you can let your constituents know how to do that. You'll be in listen mode only, of course, but we want you to be sure to put any questions that you do have into the question box, and definitely invite you to do that. Jennifer and Taylor can't answer specific questions about your situation, but they can give general information that you may find helpful. So again, thanks so much for joining us, everyone, and I'll go ahead and turn things over to Taylor and Jennifer. Thanks for being with us, guys.
Thanks for having us. Oops.
Okay.
So today we're going to be talking about being prepared. A lot of people are thinking about sort of end-of-life issues because of everything that's going on in the world, and so we want you to be prepared. And we're going to talk a little bit about probate court and what kind of things that you can do to be prepared for sort of end-of-life issues. And so like she said, I'm Jennifer Rainville. I'm in our Columbia office. I'm the unit head for probate and heirs property. And then Taylor is in our Orangeburg office, and she is our elder law unit head. And so these are the different things that we're going to talk about today. But sort of first and foremost, we want you to be prepared, right? So you need to have a plan in place. You need to think about these issues. Nobody likes to think about these things. We all think we're invincible and that nothing bad's going to happen, right? And so we just want to make sure that you kind of think these things through, that you have a plan, and that you make your wishes known in writing to people, right? Because people remember situations very, very differently when we're having conversations. What I pick up on may not be what another person would pick up on. So I think that's super, super important. And so when we talk about advanced directives, Taylor, do you want to talk about living wills a little bit?
Yeah, let me know if there's too much background noise. So with advanced directives, and I did a presentation where the same in the Level Up Law series at the end of June. I think it might have been on the 30th, that goes through these in more detail, and we answered some questions. But advanced directives are a way of letting people know what your wishes are before the time comes where decisions need to be made. So advanced directives, in my mind, they do include a will and estate planning, but really they're about what needs to happen while you're still around but may be unable to make decisions for yourself. And so here we have a list of what are the advanced directives in South Carolina, and those are a living will, healthcare power of attorney, physician's order for scope of treatment, which is a post, that's relatively new, and then a durable power of attorney. And so one of the reasons that you may want to consult with an attorney at legal services or in private practice would be figuring out how these documents can work together. So you wouldn't necessarily need to have a living will and a healthcare power of attorney. One of the ways that I help a client decide if they need one of those is to talk to them about their life circumstances, what things in particular they have going on in their life, and we can figure out what's the best fit. Does that mean you can't have both, but they work together? How do they work together? So consultation with an attorney can help you understand the needs that you have, and also can make sure that these documents, when necessary, not either of the ones that I've talked about, but make sure that they're recorded and are valid, and that the person named in the document, if they have some powers to act on your behalf, understands the powers and rights that they're taking on. And so I think we hear about these things in, just kind of as we live our life, we hear about durable powers of attorney and we think we understand what they are. And I certainly have legal knowledge of them, but I think what the public may think of those documents and how we may use those phrases in our day-to-day life is not actually what the legal things are in these documents. And so, often we'll have a client that comes to us and thinks they need one, when really they may need 2 or 3 for the situation they have. But it's a good way of thinking about how to make your wishes known before you're unable to communicate that to family members or who you want to care on your behalf.
Right. And so the living will and the healthcare power of attorney and the post, those all deal with making medical decisions when you're unable to sort of make them on your own, and sort of just a general overview of those things. The living will and the healthcare power of attorney are statutory documents. They're in the code section. They can literally be copied and pasted into a document. Post is something that you do with your physician that goes into your medical order. So it's like a medical order for treatment as opposed to like a legal document. And so those things help people make medical decisions for you once you're unable to make them for yourself. So as long as you're able to make your own medical decisions, you're going to be the one driving that bus, is what I always say, making those decisions until something happens, right? You slip, trip, and fall and bump your head and you're unconscious. Or maybe you have a cognitive decline that sort of happens over a period of time and you no longer understand or can give what the doctors call informed consent, right? So those are really important things to remember. When you pass away, that healthcare power of attorney, that living will, that passes away with you, right? It's no good after you pass away because you're not really needing to make medical decisions after you've passed, right? The next thing that's on here, the durable power of attorney, has more broad sort of powers, right? So not only can you use it to make medical decisions, but you can also use it to make financial decisions. And so that's where that document can be pretty scary, because you're giving somebody a lot of control over the ability to make decisions for you. And so I've seen those in my years here at Legal Services go horribly, horribly wrong. And I know that Taylor has too, because we've talked about these things. So it's super important that if you decide to do a durable power of attorney, that you talk it over with a legal professional, you make sure that it's right for you, and you appoint somebody that you absolutely 100% trust, that's going to do what you want and sort of act ethically all the time, right? Don't appoint somebody who has a criminal record for embezzling, because that's not a good idea. I've seen that. And make sure that it's somebody that you have that has an understanding of what it is that you want, that's not going to sign you into a nursing home if that's not what you want or what you need. And then it becomes an issue of whether or not you have capacity to say no to that.
And I think that one of the important conversations that I try to have with clients when we're executing or signing these documents is talking to them about the importance of, even if we're doing a really specific healthcare power of attorney, we're not giving, we're giving very limited ability for that person to enact decisions on behalf of the person signing the document. That the follow-up conversation is still let family know what you're deciding. Like, go ahead and have those conversations, because if you're in a frame of mind where you're starting to think about advanced planning, and it may be because you have a current medical situation where you would need to think about those end-of-life decisions, or just because of circumstances in the world and wanting to be prepared, which makes sense, you want to go ahead and have those discussions with family members so they actually know what your wishes are. I think I have a lot of clients who, when we're going through the document and I ask them, do you want somebody else to make this decision for you, or do you want to go ahead and declare your wishes of if you want to receive treatment or want it to be withheld? And they don't know. And I'm not gonna, we'll take some time, we'll talk through what the document means, but it happens probably about once a year that I have a client that we get into the signing process of the document, and I'm asking them about those serious decisions, and they don't really know. And so we stop the appointment at that point and we reschedule it for a couple of weeks later to give them some time to think. And then they need to know when they come in to sign it again, what they want to do. I don't want to name anybody that isn't, the first person that you think of to make those decisions on your behalf that's going to do a good job. We want to think through it, because there are mechanisms, and we'll get to this in a little bit. There are ways that the court can appoint somebody to make these decisions for you if you don't have these documents in place. But we also want to be careful in situations of what advanced care documents are appropriate. And we've already mentioned you want to consult with an attorney who knows what these documents do and don't do, and can give you some advice about who you might want to appoint in those different documents, because it's not always the same child or family member that you might want to have those same powers over you.
So again, it's super, super important when you are making these documents that you are looking at somebody who's going to honor your wishes, right? And make those care and treatment decisions that you want. And to execute these documents, you do have to have capacity. So you shouldn't wait too long to do that. And so capacity to execute these durable powers of attorney, healthcare power of attorney, it's contractual capacity. So that's pretty high. You've got to know and understand the contract and be able to understand what it is that you're signing and sort of the legal implications of that.
And there are situations in which somebody may have a diagnosis that we would think on paper that person doesn't have capacity. So when we meet with clients that are coming in to do an advanced directive, Jennifer and I both kind of have our own set of questions that we'll ask and figure out, is that person oriented to place and time? Do they understand the document that we're signing? And so just because somebody has the diagnosis of dementia or I've had clients before that had a minor brain injury or other types of cognitive impairment, doesn't mean that we can't do it. It just means that we need to be a little bit more careful about how we analyze that person's capacity. So if you're already someone who is addressing those kind of concerns for yourself or for your family member that you think may need an advanced directive, there isn't a brick wall that happens just because they may have some limitations. It just means we're going to be a little bit more careful, a little bit more thorough with the process we put into place to make sure that they have capacity.
So if you don't have a plan in place for those healthcare decisions, there is a law in South Carolina called the Adult Healthcare Consent Act, and it lays out an order of priority if you don't have a healthcare power of attorney in place. And it says, these are the people who are authorized to act if the person can't give consent anymore. So that's very typically the standard people, right, that you would think of, somebody named in one of those documents, a spouse, an adult child. Now, where that becomes a problem is if you have 5 or 6 adult children, maybe they don't all agree about your treatment. So that can become sort of an issue that then the court needs to get involved with. Or if there is no immediate family members who can make those decisions, or maybe somebody more removed is the person that's been caring for them, like a niece or a nephew or something along those lines. And so in that case, then somebody might need to file for something called guardianship or conservatorship. So when we talk about guardianship, that's a person that the court names that's going to make decisions about a person's health and welfare. A conservatorship is a person that's been named by the court to look over someone who is incapacitated, their finances, their physical assets, their money. So that's what those two different, causes of action are. And it's not simple. I get lots of people who come in and they're like, I want to run down to the courthouse and get guardianship. Well, you're taking away someone's rights. So it's not simple, right? And we want to have people making decisions for themselves to the most extent possible. So we wanted them to be engaged in that decision-making process if possible. And so the court really favors this sort of supportive decision making, and you have to sort of prove which rights you're going to be taking away from this individual, right? Because we definitely don't want to take away people's rights just because they might have a disability or something along those lines. That's, you know, super important. And then filing for a guardianship and conservatorship, it's a summons, it's a petition, there's a filing fee, you have to provide the court with a SLED report, a doctor has to sign off that the person is incapacitated. It's a very detailed doctor report. And then there's a guardian ad litem appointed for the incapacitated person and an attorney. And so there's a lot of court costs that are also associated with one of these actions. So it can be quite expensive.
So there were recent changes, and not recent, but in the last 2 years, 18 months, I guess, there were changes in the requirements of how the process you have to go through to get appointed as somebody's guardian and conservator. And I think the court was trying to, like you said, trying to give those people the ability to retain as many rights as possible, because just like naming somebody as your agent and a durable power of attorney and it being really broad, and it gives that person the ability to take advantage of somebody that they have access to their finances and their information. The blanket guardianships and conservatorships we used to see in probate court were ripe for exploitation. And so the process has become, they've moved around a couple of different parts, I think, in an effort to try to streamline the process, but it's become more expensive to petitioner, I think, of the cost that they're being asked to pay. But there are extra layers of protection the court has put on to make sure that guardianships and conservatorships are not granted in situations where they're not appropriate. And I think the most common source of referrals that I have for guardianships and conservatorships is a physician, or like it's a parent who's been caring for an adult child with some incapacity, and that kid approaches their 18th birthday. The parent thinks, well, I need to go and get a guardianship conservatorship over this child, when really, what's the reason for doing it? And occasionally there is some need to pursue it, but most of the time, my first question is, well, what are y'all having problems with right now? Like, what are the difficulties that you're seeing? Is the doctor not letting you go back in for an appointment with the child because the Adult Healthcare Consent Act, in situations where there's actual incapacity, may allow you to continue participating? But also the child, if they have the ability, not child, they're 18, but if they allow you to come into the appointment with them, or they have the ability to sign a HIPAA release or otherwise acknowledge the physician, there may be other ways for a parent to remain involved and continue to, like you mentioned before, the supported decision making. That's the model that our South Carolina Department of Disabilities and Special Needs uses, the idea of, I think sometimes they say circle of care as well, and that's supposed to be the coordination between the consumer, I think is what they call them, but the person receiving services, the family members, the medical professionals, social work, voc rehab, whatever it may be, to make sure everybody's on the same page to provide care for that person. And that model, I think, works really well for an adult to continue to care for a family member or a loved one who has disabilities. It's like you can all be on the same page and recognize the capacity that person still has to take care of themselves without filing a guardianship or a conservatorship. And so I think that I have more cases where we figure out how to not file a guardianship conservatorship where it's not necessary than I do where we actually file for a GC, just because I think most of the time it's not necessary. There's other things that we can do, but certainly, and there also is the ability in those cases to be appointed as a limited guardianship, or for something for a specific period of time, or an emergency situation where the process is a little bit abbreviated. But the nice thing about the changes in the law is there's now more uniformity county to county when it comes to that GC process, unlike the state administration, where it's 46 counties and 46 judges and 46 ways of doing it.
Right. And I think too, the other thing to think about is when we're talking about sort of protecting people's rights and the supportive decision making, there's a lot of things recently that have been in the news, including like the Britney Spears, she has a conservatorship over her. And so when you're thinking about people who have conservatorship, she's working and has a job, and like that seems real. I mean, that doesn't make a whole lot of sense. So it's important that we're protecting people's rights, disabled people as well as, or people with disabilities, as well as getting them the services that they need. Okay, so now we're going to talk about last wills and testaments, or commonly referred to as a will.
So with the documents that we've talked about already, as far as advance directives, like Jennifer had said earlier, those are the documents that you let your wishes be known before your point of death. All of those extinguish or go away at your point of death. One of the most frequent questions I get when I do presentations on advance directives or on wills is, well, am I not the one that's responsible for filing everything with the estate because that was the agent and the durable power of attorney? And the answer is not unless you're named in the will or unless the court appoints you if the person died without a will. So it may be the same person. The will is the one who controls who's responsible for filing those things. So.
And you have to have capacity to execute a will. Capacity to execute a will is a little bit lower than capacity to execute a durable power of attorney or healthcare power of attorney. You have to know what you own and who your heirs are and who you want your property to go to. And I'm oversimplifying it, but that's basically sort of what we have. Only your original will is valid. So once you execute that original will, you have to safeguard it, keep it in a safe place, a fireproof box, a safety deposit box, something along those lines. And your heirs need to know where it's located, right? Specifically the people that you've named as your personal representative or the person that is going to go to the probate court and handle all the paperwork, because they have to be able to put their hands on that original will. I can't tell you how many times people are like, I can't find the original, and the court won't accept a photocopy. So again, safeguard that original will. Don't write on it. If you get mad at somebody and you want to write them out, right, you need to see an attorney and update your will.
And there are major life events when you would want to consider redoing a will. And those are usually marriage, divorce, birth or death of a spouse, birth or death of a child. Because your will is what's going to control, not necessarily who you may be married to or divorced from or number of children you have when you pass. And we'll talk about that, I think, all of those in a minute. But it is important just to think, if you're redoing something like the designated beneficiary on a life insurance policy, you might also want to think about doing a new will as well.
And so why is a will important, right? So it's important because if you don't have one, right, state law is going to determine who inherits what. And that can get kind of messy, especially when we have blended families like stepchildren and stepmoms. All the ugliest probate cases that I've had have all step parents and stepchildren. And so if you pass away without a will, state law says that your spouse inherits 50% and your children divide the other 50%, right? And so that also includes a spouse that you've never been divorced from, that you've been separated from for 30 years, right? Like we have lots of cases of where people have estranged spouses or they've been separated for, 10, 20 years. They don't even know where the person's located. That person is still technically entitled to a portion of your estate. So there's no such thing as common law divorce. You need to get those sort of things in order before, it's too late.
Yeah.
Go ahead.
No, I was gonna say, like, common law is a question that I get all the time. So I also practice in family court. And so common law is a factual determination that either the family court, the person still alive, or the probate court can make to determine, is someone, this deceased person's spouse, should they inherit some portion of the estate? And that's a fact question that's really hard to prove. The law in South Carolina changed a year ago, where the facts to establish common law marriage had to have been established before, I think, July 1st of 2019. So you may think, oh, well, the situation that I have would mean that this person is going to inherit from me. They may not officially be my spouse, but I consider them a common law spouse. it is a very difficult process to prove that someone is common law. It has gotten even more difficult since we had the decision that came out last year. That was it a statute or was it a court decision?
It was a court decision.
Okay. So it's something that's saying that even if you have those facts in a living situation that would indicate common law, we can only use facts that were in existence before July 1st of 2019. Right. So, and again, it's very difficult to prove. The only example of common law that I can really think of is you signed a marriage license and you got married, but the pastor never sent it in. And so technically there's no marriage license the probate court ever received. That is a fact pattern I've had before. And in those situations, that's kind of a slam dunk common law, but that's the type of extreme facts that it takes to show common law.
Right. It's a pretty high burden, and that's not something that I know probate judges don't like to find that unless it's very, very clear cut. You can't, a lot of what I see is, oh, we were planning to get married, right? Like we were engaged and we refer to each other as husband and wife, but that's not all of the facts that you need. It's much higher than that. Okay.
And a note on blended families, what I find here in South Carolina is also the idea of someone that was raised with the family, like a child that was raised with the family but was never formally adopted. And they may be a biological relative, but they're not within that close degree of relationship where they would actually inherit from the estate. So for that, that's an example of somebody that would not inherit, didn't have a will, would be a raised child or a stepchild. I think Jennifer already talked about that. But unless it's a biological or legally adopted child, they're not going to inherit. And that's just, I think, sometimes a difficult thing to realize, because you think, oh, well, I've raised them, they've been in my house, why wouldn't they inherit from me? And it's just because the intestacy statutes have to limit who can inherit from the estate. And so they go a certain order, but it follows biological or legally adopted degrees of relationship.
That's right. And so when we talk about probate court, Taylor's already sort of given the spoiler here. There are 46 counties in South Carolina, and they all vary very differently. So what we're going to go over, because this presentation is being sort of broadcasted statewide, is just sort of general things that are that are universally true, right? So there are two different kinds of, well, there are lots of different, but the two main kinds of estates, right? We have what we call a small estate. And so that would be if somebody doesn't own real property and they have less than $25,000 in assets, okay? And that's, there is some math that goes on there because it's $25,000 after you minus out the cost of funeral expenses, right? So again, you have that small estate. That's a very streamlined process. It's opened and closed very quickly, and it's fairly simple. The other type of estate is what we call full administration. That estate is open 8 months to a year, typically. It requires an application for probate. All of the heirs have to receive notice. So that means you have to know where they are. You have to have mailing addresses for them. But the cool part about probate court is that it is very user-friendly, right? They can't give you legal advice, but everything in probate court, there's a form for. Court staff, super friendly in every county that I've ever been in. And they're really great. It's a court of the people, right? So a lot of people are able to handle the estates of their loved ones on their own because everything, like I said, is form driven, and the court will give you a sheet that says, here's what you file and when you file it. And the forms can be a little confusing. And so that's when we get a lot of people who come to us, I just need help filling out the forms. And that's something that we're able to do.
And I think even in the small counties, it will be the probate court judge, and then there'll be a clerk. And that clerk is responsible for all the files that are in the probate court. So it's not just estate files. And at Calhoun County comes to mind, that it's Judge Brown and her, Miss Vogel, her clerk. And there have been times where I've been to pull an estate file and ask the clerk a question, and Judge Brown will overhear, and she'll come out of her office and answer a question. So most of those offices, especially in rural counties, are rural friendly. Most of the time, the probate court judge will also have been a clerk at one point So there's somebody who's been in that office or that area of the courthouse for a really long time. And I think that they will try to help you resolve stuff as much as possible, but there are things that are just beyond their ability that they can't help with, that they're not supposed to give legal advice or treat anybody any differently, but they are really friendly. And that's not, I think, just in my experience as an attorney, that's consistent with what I've heard clients say, like they've tried to go and resolve the issue by themselves, but they need counsel.
Yeah. And I also think, so one of the documents that does come up is at the end of the estate is something called a deed of distribution. And that's the legal deed. It's not really a deed, but it is, that transfers the real property from the name of the decedent or the person who's passed away into the name of the heirs. And that is something that really needs to be done properly. And so if it's something that you're struggling with or you're at that point in an estate, please come to us. We do those all the time. It's fairly simple for an attorney to draft one of those documents, whereas somebody who doesn't really have legal training is going to be very confused. So please.
The document, the deed of distribution will reference things about the estate file. So it'll say when the person passed, when the estate was opened, but really the function there is to describe the property, where the deceased person got their interest in the property from, and then who the heirs are and what percentage interest they'll receive in the estate. So the most important thing in that document, or the thing that can cause problems later, is both the property description, making sure that that's correct, but also importantly, hooking it to the last deed. Like it's what we call a derivation clause. And that's the part that states the deceased person got their, this is what the language is, but what it means is the deceased person got their interest in the property by this deed that was dated and recorded there. Because one of the things with, and I'm maybe getting to what Jennifer's getting ready to talk about, but one of the things that we are required to show if you own property, like if you've bought a house, or you have a family member who's purchased a house, they'll have a deed with their name on it, but it states where that person that they purchased it from got their interest in the property. So those derivation clauses in the deeds go back like a chain, and that's why it's called a chain of title. But that's the important part in a deed of distribution, is to show where they got their interest from, because when that property is sold or inherited from somebody else, that new deed will reference the deed of distribution, and that'll have a derivation clause in it stating where this person who purchased or inherited the property got their interest from. So you want to keep that chain of title from one deed to another, from one owner to another, strong, because it's important just to be able to show who owns the property. So when we have fights over who owns it or boundary lines or stuff like that, we have valid documents to go forward with. And I've had estates where I'm doing the deed of distribution for the estate, but there was a handwritten or non-attorney deed of distribution from a prior estate where my client got, where the deceased person got their interest in the property from. My client's normally the personal rep in those situations, and it can cause problems. So sometimes you're going from one deed of distribution to another, and that's why you want to make sure that they're done well.
So the next thing that we want to talk about is heirs property, right? So kind of what does that mean, right? So when we talk about heirs property, we're talking about property that's owned by sort of multiple people. Sometimes we're talking about multiple generations. What we see a lot, especially in rural South Carolina, is that nobody ever probated grandmama's estate, right? She died 30 years ago, then mom died, then, mom's children died, and you may have grandchildren living in the property or whoever, but we've got multiple people who have passed away and everybody had, 9 or 10 kids. And then what that ultimately means is that all of those people and all of those heirs own an interest in the property. So it's just like a piece of pie that basically the property keeps getting divided more and more. And all of these people sort of have ownership interest in the property. And it, when we're talking about a house, right, just on a lot, you can't draw lines and divide it 125 times because you would end up with just a little sliver. But the way that the law works is that all of those people actually own the property together. So they all have the ability to use the property and all of that. So that can come into, that can be problems, right? Who's going to pay the property taxes? Those properties are difficult to insure because an insurance company isn't going to want to cover them, or they'll issue you some crazy check that says to the estate of that you can't get cashed. So that can be a problem. You're paying a higher tax rate if we have a natural disaster, because this is South Carolina and we have a lot of those. FEMA doesn't want to do repairs on those homes. And there's a lot of like economic, you know, home repair grants that you may be eligible for if it wasn't heirs property, that they're not going to help you because you don't have clear title to the property. So it's really, really important that we try and limit heirs property by doing the probate process, by having a will, not naming a bunch of people as heirs to inherit a piece of real property, because we have to think about it practically. Who's going to live there? Who's going to pay those taxes? Who's responsible for upkeep and maintenance? Those kind of things.
And heirs property is created if an estate is not administered within 10 years of the date of death. So the estate process that Jennifer and I just finished talking about cannot be used if the person has been deceased for more than 10 years. So if you go to probate court, and you may have an original will for your dad who passed in 2008. If you're just not going and it's 2020 and you're 12 years beyond the date of death, they're going to say, once they see the death certificate or the obituary that has the date of death on it, that you can't use the estate administration process. And so then you get into the area of having to use a different process to identify the heirs, to have the court acknowledge who the property should pass to. And I think one of the most frequent ways that these cases come to our office here in Orangeburg is we have 2 different organizations in our region here that do, and USDA actually is another one, that will do either grants for repairs or for other things to a property, but the person has to have their name on the deed. Sometimes they even have to be the sole owner. And so they'll come to us and they'll say that they have an understanding of how long they've been living there. So they may have been on that property since their mom died in 1970, and they've been living there paying the property taxes. And there's this common misconception that living on the property or paying the property taxes means that you own the property. And it doesn't. It means that you've taken care of it. It means that it hasn't gone up for a tax sale where somebody else could bid on it and own the property, but it doesn't mean that you own it. And you may be somebody who is entitled to a percent interest in the property. So that's the other thing that happens. The further we get away from the person's death and the more relatives there are, there may be a number of other people who are going to have their name on an eventual deed that gets done for the property. And it can be that, I think you were mentioning like slices of pie, like it can get pretty skinny. You may think, well, I'm the one who's lived here, I'm the one who's taken care of it, I get the whole pie. When the law would say, these are the people who we identified who have an interest. The other thing about if you wait more than 10 years to administer an estate, if that person had a valid will, they went through the process of getting a properly prepared, beautifully executed, signed will, and you have the original, it's no longer valid. So it does no use whatsoever. And I think that I've seen that all the time. I've seen beautiful wills that I even have seen the original before, and the estate was never probated. And so that 30-page will that had a beautiful trust language in it does not matter, and it was wasted money.
Yep, I agree with that. I've seen that as well. It's really sad. You know, because when we talk about that action that has to happen after 10 years, when we're trying to straighten that out, it's called a petition to determine heirs or a petition to establish heirs. Those are expensive because the court requires lots of certified documents, right? Death certificates, birth certificates, obituaries, you know, funeral programs, because the court wants to make sure that the heirs that you've listed are all of the heirs, right? And that we haven't left somebody out because we didn't agree with their lifestyle choices or they whatever. So it becomes a real expensive court case because those birth certificates and death certificates are like $20, $25 a piece. And then you still have to serve everybody that is a potential heir. And then you got to have a court hearing, and you've got to have a witness who isn't related that can testify about, you know, who the deceased person is, who their kids were, how they would know that. So it is a complicated process, and a lot of our clients, the biggest burden is coming up with all of those documents that they need. So it can be really a challenge that could have very easily been resolved if it had been filed previously, because people die and they pass away and they move and that kind of stuff. And so that makes it hard, even harder to go through one of these things, especially after the 10 years.
And there is an ability within both an estate and a petition to determine heirs action. Like, let's say there are 10 heirs that are named either in a will or in an heirs action that are identified. And the whole goal of the case is to have one person's name on the deed so they can qualify for a repair grant, homestead exemption, you know, whatever they need to have to get a lower financial burden for remaining in the property. The heirs can come up with an agreement among themselves or ask the court to order there to be some different outcome for who will be named on the deed of distribution, or who the court will identify in an order as the heirs of the estate. That's another thing that you probably need to have the assistance of an attorney for, to draft that agreement. But one of the easiest ways is to have a will that identifies few heirs. And I don't do very many where we have more than, like, you know, one or two or three people that are inheriting a piece of property. But at least once a year, I will have a client that insists on putting every single child, grandchild, even if they're from different branches of the family, on that piece of property. And the thing that I have to explain to them is, you are creating fractional, you know, many people who have small percentage interest with these properties. And the problem that may come along, like Jennifer already talked about, is they may want to use the property differently than everybody else is using it, yet they all have, under the law, equal use to right and enjoyment of the property. And so that means they can all live there, they can all do whatever they, you know, that unless they have some agreement otherwise, they can all use the property just as the person would when they were still living. So I think that a large part of my practice and doing, and I wouldn't even really call it estate planning, but doing advanced directives and wills and estate administration, is helping people realize that what they may want to put on a piece of paper, and that will is not going to be read until, you know, nobody's really going to look for it until after you've passed, that you need to write those things in a way that will best serve your family more so than their feelings. And that's a tough conversation to have, you know, like, you don't need to put all of your children down as like, I hate doing co-administrators of an estate or like joint personal representatives. I like to do one and then an alternate, but I have some clients that insist on naming all of their children as the personal reps of the estate. And I don't like doing it, and courts don't like doing it. So there may be things where you have concerns about how your family relationships will play out in those advanced directives, but the end of the day, the question in all of those are, what are best going to serve your interests while you're still living, and will follow your wishes. And then with a last will, it's who is going to serve the interest of the heirs the best, you know, and make sure that your wishes are followed when it comes to who inherits from you. So those are some hard conversations to have sometimes when people haven't talked about them. But I think that that's a large role that we play as attorneys, is helping people figure out, not telling them what they want, but helping them figure out and think through the wishes that they have.
Right, because I think a lot of people are like, oh, I'm okay with it being family land, until they understand sort of the legal implications of that, like who's going to pay the property taxes and FEMA and all of that stuff. So I think that it takes, you know, an attorney sometimes to explain through all of those consequences of why it's important to make a plan and why it's important that, you know, you put a plan in place. So I definitely agree with you, Taylor. So now we are to the point where questions. Susie, do we have any questions?
Yeah, we do have some questions. So let me bring those up here. First of all, What if you are an heir and your parent is in a lawsuit? How does that play out for the person who hasn't yet inherited anything because their parent is still alive, but there's a lawsuit going on, it sounds like?
So I can answer that one. So the person that's appointed as the personal representative of the estate has the ability to be named in a lawsuit or defend a lawsuit and take actions on behalf of the estate and of the heirs in that lawsuit. The assets, so let's say it's like a car wreck and the person unfortunately passed away and it's a like personal injury case, and those assets are payable to the estate. That would be something where those would be administered or given out to the heirs following the instructions in the will or the inheritance or intestacy statutes. So that money, if there is a settlement or a judgment paid to the estate, could be something that would be given to the heirs eventually.
Okay, and here's a question I can answer. Is this being recorded and will it be available to view later? And the answer to that is yes. It will be available on our YouTube channel. Should be available later this week. So you can look to get this information available for you to review it a second time. Here's another question. Does the deed have to state heirs for it to be considered heirs property?
So I think that this is what they're asking. It doesn't, when a person passes away, if the property is never probated, it stays in the name of the deceased person. So the heirs aren't actually even listed on that deed until some sort of court action is taken. But if you have a piece of property that has gone through the proper probate process, it's going to list the name of all of the heirs who have inherited that property, as well as their interest. Usually it's off to the side in little parentheses like 50% or as a decimal point, depending on who drafted it.
Okay, very good, distinguishing the use of the word heirs. So here's another one. Once you have a written will, what is the next step? How do you make it legal?
So if the will has been properly executed, it's got your two witnesses who are disinterested, you have the original will. Some states require it to be filed with the court. South Carolina is not one of those states. So you need to keep that original will in a safe place, a fireproof box, a safety deposit box, something along those lines, something that's going to be safe in the event that you have some sort of tragedy in your home, like a fire or flood or those kind of things, so that the document can be preserved. And you're going to want to make sure that the people that you've named as your personal representatives or the people that are going to handle doing the probate paperwork knows where that original will is located.
And I think there's the misconception. So probate courts in South Carolina did allow you to file a will packet at one point. And so some courthouses, I think you're right, that you can go into and there's will packets that are there. That may be the old estate files. But you can, after someone's death, there is what's called filing a will for record, which is after the death, somebody presents the original will to the court and the estate is not opened at that point for some reason, but the original will is sent to the probate court. So
typically, I'm sorry to interrupt, but typically that's if maybe the person didn't actually have any assets, but they did a will, like maybe when they did the will, they owned property, but they sold it because they went into a nursing home or downsized or whatever. So typically then you still want to file the will for record because we want to preserve it. We don't want it to expire, just in case later you find out that there is a mutual fund that you didn't know about, or some piece of property somewhere else that needs to be dealt with.
And estates that are closed, so once you finish out and you maybe had property and you did a deed of distribution, you found out years later they actually had an interest in other property or mutual fund, pension, whatever it may be, the estate can be reopened for subsequent administration to administer or, give out those assets according to, the will or the inheritance laws. So it is important to present the will if you have it after the death, even if there's nothing that needs to be done with it.
Right, it just needs to be presented as soon as possible to the probate court. There used to be a statute that said within 30 days. It no longer says that. It just says as soon as possible. So obviously, when someone passes away, it is a traumatic experience. There's a time period in which most people need to grieve and are not going to run up to the probate court the next day, right? Just like you're not going to get the death certificate right away. Those are taking, it's my understanding, weeks to come in the mail. So, you're not going to be able to file till you have that stuff anyway, but just doing it as soon as possible.
Okay, and here's a question that I think covers somewhat of a common misconception that we often see, and it's asking if you had a power of attorney for someone, but then they passed away, can the power of attorney that you had help you to get the property once they passed away?
No. So when you have a power of attorney or you give someone power of attorney and you die, your power of attorney dies with you. That's the easiest way to sort of think of it. That document expires upon the death of somebody. Also, I would be you need to be a little cautious of somebody who's wanting to gift themselves your property. If they're your agent, that can also be a very big problem. But again, that document dies with you, so that's not a useful tool. You need to have a will to take care of your property after your death.
And agents and people named in advance directives have a duty against self-dealing. So one of the restrictions is they can't, using the power of attorney, take out a life insurance policy. This is one of my favorites. Can't take out a life insurance policy for the person that they're acting on power of attorney on the behalf of the the agent, the subject of the durable power of attorney, I'm forgetting my terms, and name them as themselves as the beneficiary. So there are limitations in the law of what an agent can do acting under the color of a power of attorney. And there is also a duty to act in the best interest of the person that they're the attorney, in fact, or the agent for. And there are some criminal penalties for that, like where they could be prosecuted for misuse of that. And possibly there are ways to have things undone. So transactions that somebody does as using that power of attorney can possibly be undone at a later date, but it's difficult to show that they are acting against the interest of the person or that they were doing it causing fraud. So that's another reason to be really careful that you name the appropriate person as your agent.
And speaking of that, here's a question of what can you recommend to someone who does not have a good candidate? You said how important that was. They don't have a good candidate to use in the power of attorney. Is there anything else that they can do?
They should not do a power of attorney. So the living will allows you to make some healthcare elections and doesn't require the naming of an agent if you don't have somebody that you feel comfortable naming, right? But it would allow you to make elections about end of life care and tube feeding, that kind of stuff. But if you don't have somebody that you can trust, you don't need a durable power of attorney. There are other vehicles that are in place. If you become unable to handle your finances, if your sole source of income is Social Security, Social Security can appoint you a rep payee or a representative payee. Sorry, I shortened that a lot. Or somebody can go to the court and petition for conservatorship or guardianship over you. And at least then there's some court oversight and they have to provide accountings and things like that. There are agencies that do provide some conservatorship services and charge a small fee for that. But if you don't have somebody that you explicitly trust, then I would say you don't need that document.
And I think even if you have somebody that you're like, they make good financial decisions, or I'm okay having them on this one checking account, that still doesn't mean that you need a blanket power of attorney. And I frequently will see ones, because these get recorded. So I sometimes get curious and I'll look at the ones that other attorneys have drafted. And sometimes they are so expensive. They'll be 30 pages long. They'll cover financial, they'll cover healthcare. And I advise clients, like the way that I think Jennifer and I are both on the same page with this. We may name the same person as the healthcare agent and the agent and the power of attorney, but I'm not going to put them together. Like I don't put those documents, I don't have healthcare provisions in my durable powers of attorney, especially because they get recorded, and healthcare powers of attorney do not have to be recorded. So the only document that we've talked about today that ever has to be recorded to be enforceable, and that's recorded in the county office where deeds are recorded. So that could be clerk of court, register of deeds, register of Mesne conveyance. That's the only one that has to be recorded. Obviously, wills have to be filed with the probate court afterward. But you don't need your personal healthcare decisions to be a public document. Not a great idea. The register of deeds will accept the healthcare power of attorney to be recorded, and will charge you a fee for it, but it doesn't have to be recorded. So.
Okay, here's another one for you guys. When a will states in the body of it that the personal representative can be changed if it's done in writing, what's the correct way to do that?
There's a process after the estate has been opened to have a personal representative renounce their right to serve and nominate somebody else. So there's that way to do it once the estate is opened. There are amendments that you can make to a will. There's what we call a codicil, which is changing any of the significant portions of the will, like who you're naming as the personal rep, who's going to inherit real estate. But those have the same signature and witnessing requirements that a will does. So normally we just suggest you reading the whole will rather than having the codicil done. And then a memoranda is where you're changing who inherits personal property, like you're leaving additional instructions, and that has different requirements. So as far as changing a personal rep, you could do it at codicil. That would have to be the testator, the person writing the will, redoing it before they pass. And then there's a way to swap personal representatives by an agreement among certain people after the estate is opened.
Okay, so what about going back to the heirs property? We have a question just in general regarding when you have a good number of heirs, like say 8 or 10 heirs to a particular piece of property, and some want to pay taxes, they're part of the taxes, some don't. What's the legal recourse that forces them to do that? And also, what are the risks involved with taking that kind of action?
So I think what this question is getting at is, so yes, you all have a duty to sort of chip in to the taxes. And if you're inevitably going to have an heir who's just not going to do it, right? So you could potentially bring an action against them to try and recover that amount, but it, again, that's a court action. It can be kind of expensive to do that depending on what the dollar amount that you're trying to recover is. So it's not super easy. Obviously, if that person wanted to sort of say, I don't want to fool with this, right? Like sometimes inheriting property is not a great thing because you're inheriting the responsibility that goes with it. And so that heir can say, you know what, I don't want to pay taxes, but I don't want to have an interest in the property either. Let me quit claim my interest to whoever, and they can make a decision to do that, to quit claim their specific interest over to another heir or whatever the case may be.
Okay.
Is that it for questions?
We do have some more questions. Yeah, and actually one of the questions is, how can I get in touch with you if I do need to apply for services? And we're giving you that information here on this page. And one person asked, is there a way to get a written copy of this webinar? It's a lot of information. I think actually there's a way to do that on YouTube, but
Well, I also,
for us.
I'm sorry, Susie. I also want to direct them to our Law Help website, because we did just update all of this stuff. And so it sort of goes over an overview as to, there's a little paragraph description of each of those types of documents. And so there's some really great resources on our website. So I would definitely, anybody who maybe wants to learn more or is still maybe a little unclear about some of the terms that we've used today, because it's a lot of information in an hour, I would direct you to our Law Help website, because again, I think that there's a lot of really good materials and resources on there, and that was all just updated this summer.
That's great. And do you have that slide with that information on it for the Law Help?
It is lawhelp.org/SC. Oh, there we go. Never mind.
Oh, there we go.
As always.
Yeah, and if you don't find what you need there, Robbie, you can certainly email at ruralclinics@sclegal.org and just refer to this presentation, and we can accommodate you that way. It's rural, hard to say, RURAL clinics@sclegal.org.
Sorry, I was gonna say, we also have brochures. I think we have a couple of handouts and some inserts too. So that's certainly something that I don't think that we have materials. I'm just not exactly sure where all of those are. So happy to send those.
A lot of them are on the Law Help website.
Okay. One last question, it looks like, and this is just, again, regarding a deed where someone has passed away. So if the person who has title is on the deed, has passed away, but they've got a spouse who is still living, but not able to make decisions, and they've got a bunch of kids and grandkids, can the kids, as long as they're over 18, make changes to the ownership, or does it have to go through probate?
It's gonna have to go through probate. So there may be, and you know, so a relatively new-ish, right, within the last 20 years is having property deeded in what we call right of survivorship, which is something that's done between husbands and wives. And so that way, when one spouse passes away, the property automatically passes to the other spouse, and they don't have to go through the probate process, right? That's something that we've only really last 20 years or so, I think is probably the oldest deed that I've seen with right of survivorship on it. So if it's older than that, it probably doesn't have that, and it will have to go through probate, even to just get the deceased wife's name off of the property. And you know, if dad's totally incompetent and he doesn't have anybody that's looking after his stuff, then it may be that the court would want a guardian ad litem appointed to look after his interests. That's something that happens too.
Okay, well, it looks like, oh, go ahead.
Oh, no, I was gonna say, like, one important thing to note with the way that ownership is designated in deeds, if you are looking at one, is there are defaults in South Carolina. So like joint tenants with right of survivorship is very clear language that we see in a deed. So one of the reasons that you may want to meet, or that you should be encouraged to meet with an attorney when you're doing a will or trying to figure out if you need one, is identifying what you actually own. You may think you have ownership of a certain piece of property, maybe because of family understanding or language, but we want to make sure that the issues, if you do have Heirs property and you have interest in Heirs property, that the steps are taken to clear that title before you pass, so that your will actually will function to control your interest in that property. So that's one of the other things to meet with an attorney about, is you may think you know what you own, but do you have clear title to it? Is there clear ownership? So that would be another reason to meet with, you apply for services and see if you're eligible with us or another lawyer, just to make sure things are done when you're alive, because it's going to be easier for you to take care of it than to pass and to cause another generation to have to be addressed with the problems that are created with your property.
All right, well, I want to, I think that's about all the time we have, so I do want to go ahead and thank Jennifer Rainville and Taylor Ott. That's great information from two excellent attorneys on being prepared for probate and heirs property issues. And I also want to thank all of you who joined us today. We really do appreciate your interest in this subject matter, as well as other subject matter that we cover in Level Up Law. Level Up Law is a series of free legal webcasts to educate the public on some of the most commonly faced legal challenges. You can join us every Tuesday at noon to learn the basics of a particular topic, as well as how to avoid pitfalls and protect yourself. And as I mentioned earlier, you can find this and all of the previous Level Up Law webcasts on our YouTube channel. Just go to YouTube and search South Carolina or SC Legal Services and go to the Level Up Law playlist. We have various playlists of our different resources there. And be sure to go ahead and like and subscribe and sign up for those notifications so you'll know when new ones are uploaded. So just give us a day or two on this one to get it uploaded, and you can listen again. Now, look, if you have an issue and you need legal assistance and can't afford a lawyer, you may be eligible for our free legal representation. So we do want you to apply for help here at South Carolina Legal Services by calling toll free. See the number here on the screen, 888-346-5592 for those who are listening in by phone. And you can call between the hours of 9 and 6 Monday through Thursday. Our intake office personnel are standing by during those hours. And remember, and this is important, you can also apply online at the web address you see here on the screen, www.lawhelp.org/sc/online-intake. And we've got a bunch of legal resources there that are free and available to the public on this and other subjects. So please check it out. Those resources are checklists, articles, brochures, videos, our online classrooms, any number of things that'll be helpful to you. Okay, again, here at Legal Services, we thank you for tuning in to Level Up Law, and we do hope that you'll tune in again next Tuesday when we will be talking about dealing with mortgage servicers and your right to get information and to dispute errors and how you can go about doing that. An easy way to see what's coming up each week is check out our Legal Services Facebook page or follow us on Twitter and Instagram. Like and subscribe and sign up for those alerts and notifications. Thanks, everyone. That concludes today's webinar. Thanks again to Taylor and Jennifer, and we look forward to having everyone back with us next week. Take care, everyone.